Hello, Philadelphia.
Philly.
Hello, everyone. Thank you so much for joining us. Just let us know where you're logging in from in the chat, and we'll get started in just a minute. Hey, Chicago. I can't keep up. Boston, San Antonio, Charlotte, Atlanta, St. Louis.
Maryland, Burbank. Outside warmer there than it is here in Detroit. Woo-hoo.
Thank you so much, everyone, for joining. Let me go ahead and get started. Welcome, everyone. Thank you so much for joining today's ILEA webinar. My name is Gwendolyn McNutt, CSEP. I'm the chair of the Professional Development Committee. Today, we'll be presenting Ask an Expert, Contracts, Consent, and Liability, oh my, powered by Giants Enterprises. Thank you to Giants Enterprises for their continued support of ILEA. I have a couple of housekeeping notes before we get started. We will be recording today's session, and it will be posted on the ILEA Hub. Thank you to those who've submitted questions in advance, and we really want this to be an interactive session, so please put any questions you have into the Q&A box, and we'll get to as many of them as we can. And please share your thoughts and comments in the chat, and share your experience on social media using the hashtags ILEA Webinar Wednesday and ILEA Welcomes All. Today, the webinar will also feature closed captioning. Please click the CC button on your screen to view the live transcription. And finally, there's still time to submit for a 2021 ILEA Esprit Award. Late submissions will be accepted through Friday, April 30th. Submit your entries at www.ileahub.com/Esprit Awards. And today's speakers are Quintin King and Jeff Dillard of Dillard King, a professional service firm of lawyers, lobbyists, and consultants with offices in Chicago, Washington, D.C., and Atlanta. Quintin L. King is a senior principal at Dillard King. His area of expertise is risk management, governmental, and regulatory affairs. He also advises clients on risk evaluation and compliance, primarily for insurance companies, trade associations, and other corporations. King graduated with the highest honors from DePaul University and earned his Juris Doctorate from the University of Pennsylvania Law School. In addition to his practice, he serves on numerous boards and commissions and is an adjunct professor of political science at DePaul University, where he teaches a course entitled Political Scandals in Crisis Management. Jeff Dillard is a Chicago-based attorney representing entertainers, entertainment venues, actors, performers, and athletes. He is a principal at Dillard King and a senior partner at the Dillard and Noel Law Firm in Chicago. Jeff is also president of Janet Entertainment, a multifaceted entertainment firm located in Chicago with national interests in California and New York. Jeff has over 30 years of entertainment law and contract experience. Please welcome Quintin King and Jeff Dillard.
Thank you so much for that wonderful introduction, and thank you for having us. This will be fun. You know, there's nothing I like to do better than to hear my own voice pontificating about things, as Jeff will gladly tell you. Well, we're here to deliver some bad news this morning, and that bad news is this: there are no answers. If you came here for answers, you're going to leave with more questions, but that is not necessarily a bad thing. And as we get through this process and as we go through this seminar, you will learn that, you know, having more questions than answers isn't necessarily bad, because we hope you'll leave knowing which questions to ask and maybe push your brain into higher gear. On that note, I'm going to start a brief little presentation of just a general overall view of what is the process with contracts and risk management and the things, particularly in the era of COVID, that you want to think about. All righty. Can everyone see that first slide? I don't know how I can tell if everyone can see the first slide.
No, I don't think you're sharing.
Right. Let's see if I can get this right and share.
You got it.
Hey, I'm technically savvy today. Not. Well, the first thing you should know, and I know this is going to be a pain for you to know, there's no such thing as the law. What exactly does that mean? Well, if you watch enough CSI or any other law show, and I'm going to date myself by reaching back to Perry Mason, you will know that they're constantly on those shows talking about the law. Well, there's really no such thing as the law, by which I mean there are many jurisdictions where laws are interpreted, where rules are executed, where there are regulations, and where compliance looks like something that it doesn't look like in another jurisdiction. In other words, there's no single source of the law. So if you want to know the answer to something, the question of is something legal or what have you, your best bet is to understand that from the start, that there's no single answer to that. So someone in Philadelphia, PA, who has an issue with a contract or an issue regarding force majeure or an issue regarding whatever else that you might have in the process, that person's answer to the questions that they ask may be totally different from the next person. Now, if I can only get the next slide to come. Let's see. Yep, there we go. In other words, every jurisdiction has its own rules, period. Every jurisdiction has its own opinions, court opinions, which are known as the common law, and they dictate interpretations of rules and how contracts are to be read and what liability ensues from what behavior. That varies from place to place. What'll work in one jurisdiction won't necessarily work in another. What happens in one place won't necessarily happen in the other. So to ask the general question, what is the law on something, you're almost never going to have a satisfactory answer. There is a complex web of issues that you have to deal with when you're dealing with issues around liability, contracts, and so forth. What we hope to do is give you some idea about how to navigate those issues without awakening the sleeping spider of litigation. And if you do awaken it, hopefully you'll have enough stuff in place in order to navigate successfully. Allow me to confuse you for a second if I haven't already confused you enough already. I want to introduce you to your future client, National Association of Independent Chicken Farmers. They're having their annual meeting. I always said when I was a corporate denizen that I would never become a PowerPoint presenter with goofy slides. And here we are. Now, the National Association of Independent Chicken Farmers hires you to do their annual meeting. The NAICF is located in Ohio. The event's going to be in Florida. You're located in Pennsylvania. Most of your contractors will be in Ohio, Georgia, and perhaps Florida. Let's throw that in there too. So the question is, what will your contracts look like? Who will have contracts? And what laws will dictate the contracts and the risk that you will likely be assuming as a result of your work for the National Association of Independent Chicken Farmers. So you're going to have, as the meeting planner or association, you're going to have a contract with the association. You're going to have a contract with the planner, or if you are the planner. If you're not the planner, if you are a vendor, you're going to have a contract between the vendor rather, and the association and the venue and third parties. As a vendor yourself, you may have subcontractors who will also be on board, and you will have to have contracts with those people as well. Not to mention, within each of those contracts, there's likely a requirement that there's another contract, and that is a contract of insurance. Almost all contracts that say, hey, we will do this event for this amount of money, or we would like to use your venue for this event. In there's going to be some language where somebody is being indemnified, held harmless, or what have you. And proof of that has to come in the form of, you've got insurance to make sure you indemnify and hold me harmless. And we need to see proof of that. So within your contract, there will be another contract. So here's the question. When you slide over to LegalZoom to set up your contract, and this is based on one of the questions that we were asked, whose law is applicable? You got people in Florida, you got people in Ohio, Pennsylvania, and Georgia. Which law do you use to set up that LegalZoom contract you want to use to make life easier for you? Well, fact is, there are too many issues to go through to figure out where you're going to go. So my advice to you, if you can afford to hire decent counsel in whatever jurisdiction in which you're working, hire decent counsel in whatever jurisdiction that you're working.
Hey, Quintin, I have a quick question.
Shoot.
That clients often ask me, does a contract have to be in writing? Is it a contract if it's not in writing and signed by both parties?
Well, answer.
Not necessarily. I know in some venues or in some states, if it's a real estate contract for more than $500, it has to be reduced to writing. But there are lots of lawsuits about contracts that were not in writing and were not signed. So basically, for a contract, you need an offer, acceptance, and consideration. Offer, acceptance, and consideration obviously is something of value that is going to be, that is exchanged or is going to be exchanged. Once you have those three things present in the, and I'm kind of simplifying, but once you have those three things present, you know, there's a contract. There was a famous case several years ago about a Hollywood actress who purchased a very, very small, like all the real estate in a small town, and it was a handshake deal, and they went in and sued and won based on a handshake. And so, as Quintin is saying, well, what's the purpose of you if you can have a contract without reducing it to writing? What's the point? The point is proof. So now, obviously, if you have it in writing and there is a breach of the contract, then it is easier for you to prove that in a court of law than if you just had a handshake deal. So most of the times, if I'm reviewing the contracts, the client will say, "Is this a contract?" And that's really normally is not the issue. It's not, is it a contract? The issue is it a good contract for you? Because it's indeed a contract, but it could be a terrible one and does not say, you know, it does not protect you in ways that you think it does. So I just wanted to add that, Quintin, because I get that question a lot.
Could you put a pin in that? Because we may come back to especially the question of, is it a good contract for you? The other thing about, as Jeff was talking about verbal contract, one of the things I have seen in the past is someone who, let's say, is an association or an event planner goes to a hotel and says, we want to rent this space here. Okay, fine. Here's the contract for that space. Looks good. They sign off on it. They hand it back. 2 weeks later, something comes up. So, not anything major like, oh, I need to cancel the contract. Something like, look, you said in the contract that we read that we could not bring in our own food, or we could not bring in our own flowers, or that if we had to do this, we would have to have it approved by you. Is it okay that we skip that part and bring in our own, let's say, DJ? The whole many hotels, many venues will like to provide stuff like that themselves, and whether it be food, liquor, or entertainment. Let's say you go in and you say, oh yeah, we need to bring in this DJ, as a friend of a friend, whatever the case may be. Is that okay? Yeah, sure, no problem. The night of the event, you get there with jamming Jeff Dillard, the DJ, and boom, turns out that the person who okayed you bring in your own DJ isn't there that night, or was fired, or did whatever. The agreement that you just made verbally, you have no evidence of. If situations like that arise, and you see them arise in events, in event planner situations, reduce it to writing. Reduce everything to writing if you can. Take nothing for granted. Reduce it to writing. And again, back to the question: if you're doing a lot of contracts, and particularly some complex contractual work involving events, and some of you may be, you really should get a local attorney involved in every phase. Sometimes it may be as simple as having that local attorney do one contract that will cover all the event type services you provide, or that lawyer will look at the, let's say, additional insured language in the contract, or that person will be the one collecting your information for certificates of insurance to prove that you have insurance, that your subcontractors are proving to you that they have insurance, that you negotiated a deal with the venue, that it's okay that we have this amount of insurance. Here's our COIs, certificates of insurance, that, fine. Have somebody do that. If you can. I know for some people, it just seems, I don't want to spend X for, to hire an attorney to look at a contract that, everybody seems to accept, especially in this day and age of COVID, where frankly, some meeting planners and associations, people who are hiring or buying vendor services, i.e., you're going to a hotel or some other venue and you're attempting to do your event there. You have a lot more leverage now than you did, say, pre-COVID, say 4 or 5 years ago, because a lot of venues are so desirous of new business that they're willing to sit down and cut a deal with you, versus back in the old days, there was no such. It's like, here's the contract, sign it. And that still is the case in some bigger hotel chains where the manager doesn't necessarily have that much control or any control over what contract you sign. This is a contract that comes from up high, and it's been vetted by, let's say, Hyatt's legal team, and that's it. There's no negotiations, contract adhesion. It is what it is. But now with post-COVID, I've seen with some of the associations that we do government affairs work for, they're able to cut deals all over the place. Terms and agreements. Every contract you sign should have protections. Protections in the form of being able to, like Jeff was talking about, exactly what it is that you're agreeing to, or as exactly as you can be. And that kind of goes to point one I was making. I want to talk about just 2 seconds, spend 2 seconds on. There is no black and white as it relates to law. Contracts, all of that. It's all kind of subjective and fuzzy and kind of a little bit touchy-feely, where the words can be interpreted in 1,000,001 different ways. And that's one of the things that we're seeing with the whole COVID thing. And that's why the answer to almost all your COVID question is who knows, because we don't at this point. There have been some cases involving business interruption insurance. There's been some cases involving force majeure, whether or not COVID constitutes a force majeure, whether or not you can get your money back for that, whether or not who's going to be liable for losses that proceed following the reopening, and what can you do to protect yourselves as vendors and as venues and as associations and organizations that are hiring you. What can you do? There's no real simple answer. I mean, there's some things that you really should be doing, but you should be doing those things anyway, like making sure that the venue has a COVID policy, that put COVID policies in place, and that it's actually being followed. That nothing gets you totally off the hook, but that goes a long way towards saying, look, we did everything we were supposed to do. We wanted to make sure that this entity had a decent COVID policy. We did it, and that's something that I would look into. There are other provisions that do risk shifting and risk mitigation. You're probably familiar with being named as an additional insured on someone else's policy. So for instance, you are an event planner, you have a flower service, a DJ, maybe security. Hopefully you don't, because my clients are insurance companies who I do risk and evaluations for all the time, and they hate when they don't. I shouldn't say hate. They don't like you having security at your event, and they jump you through a lot of hoops if you do, in terms of making sure that those security people are trained. But at any rate, you have all these people who are your subcontractors, because you have the contract with either the association or the venue or whomever, and the people beneath you are your subcontractors, the folks that you bring in. You got to make sure that they have everything in place they're supposed to have, like you demand in your contract with them, that they have they name you as an additional insured, that they agree to indemnify and hold you harmless. The only way they're going to be able to do that, of course, is if they have insurance. You're going to collect a certificate of insurance from those good people, just to make sure they actually have them. The same goes for if you're a subcontractor. If you can negotiate a deal where somehow you end up as the additional insured on your contractor's policy, or at least there's a risk splitting effort, and which is what actually happens when you have an additional insured language in your policy and they have it in theirs. The two companies usually sit at the table and say, look, okay, well, we're going to split the cost of defense. We're going to both pay for it. We're going to both be on it until such time as one of us gets out of it. One of the really cool things about insurance is there's no necessarily any specific rules that you have to abide by. I mean, there are, as Jeff was talking about, you got to have offer and acceptance and something of value, so forth and so on. You can't have these amorphous, weird contracts that don't mean anything on the one hand. But on the other hand, we got a lot of questions about, can you put this in the contract? Can you put that in the contract? Can you put that? Yeah, you probably can. Unless it's something outrageously nuts, you can probably put it in the contract. The question is, will the person across the table sign it? You can put just about, that I, in addition to renting me the space, I need you to come in every 15 minutes and spray it with some kind of disinfectant. Yeah, I've seen people put that in new contracts, and the venue. Okay, sure, why not? What the hell? We do that anyway. Is what they're famed for saying. So you can put whatever you want in a contract, and it's fine. Again, question is what gets signed and what doesn't. One of the interesting things that a lot of people don't know about their insurance policies is that there is a provision in most policies that require insurance companies to defend a lawsuit against you, even if they think, and they're not positive, they think that you may not be covered for that suit. So any COVID stuff that may not be covered, that should not curtail you from getting every kind of insurance you can possibly get that might cover it, whether it's business interruption insurance or general liability insurance. Get it all, because the duty to defend. I said earlier that there are few things in quote unquote the law, because there is no such thing as the law. Things differ from jurisdiction to jurisdiction, to a certain extent. That's a bit of an expansive statement, but the other thing, that one of the few things that do actually exist in almost every jurisdiction, the duty to defend on behalf of a insured entity. My duty as your insurance company to defend you is greater than my duty to indemnify you. What does that mean? It means, and again, a lot of businesses and individuals don't actually know this. You have the greatest thing in your general liability policy or your business interruption policy, just about any policy where you can be a third party, held third party liable, is the defense clause. You get a lawyer with your policy, such that if there's any claims against you, let's say someone says, I got COVID because I went to an event that was sponsored by the Chicken Association, or I got COVID because I went to an event that was sponsored by the Chicken Association, promoted by Ajax event planning, and was held at the Hyatt Regency in Chicago. I'm suing them all. Everybody gets sued. That was one of the questions. Can we be sued for? Yes, you can, and you will be. The answer isn't, the question isn't, I tell people all the time, the question isn't whether or not I can be sued. The question is, will that suit survive what's called a motion for summary judgment or a motion to dismiss? You will be sued. Absolutely, you will be. Anybody can file a lawsuit about anything. What is a lawsuit? It's when you take a piece of paper, you go down to the clerk's office, usually the clerk of the court's office, and you hand it to them. You pay a fee to file it, and you pay another fee potentially to have it served. In some jurisdictions, that's different. And that's it. The clerks in those offices, their job is not to look it over and say, well, you can't sue for that. That doesn't happen. That happens later. And what later means is at a time when you as a person being sued has spent thousands of dollars on legal fees, unless you have insurance that covers that will get you out of something that you should not be in, depending on what jurisdiction you're in. So you should move on from that. Make sure you have coverage that covers anything and everything potentially. One of your biggest friends, in addition to the fact that your insurance policy will carry you up to the point when it realizes that, well, maybe that's not covered. One of the biggest benefits of insurance policy, the other benefit of being in the world of insurance, is that quite often, if you have a broker, that broker can be your best risk manager. That person will teach you how to have risk shifting and mitigation tools in every single contract you have. Hold harmless clause, indemnity clause. Typically, sometimes that's the same clause, indemnify and hold harmless. And a requirement that you name me, let's say I'm a venue person or I'm a contractor doing an events planning, and I'm signing a contract with someone who's an association, the Chicken Association. Let's use them, we have been. And they say, we need you to do this event. I'm going to hand you a contract where you're going to hold me harmless for anything that arises from a loss that arises from the activities of the association. I don't really know what those might be, but I don't want to, as the event planner, I don't want to be in a hook for your stupidity. Truth is, I'll still get sued if there's suing to be done, because like I said, there's no one at the gate saying you can't file this suit. A judge will say that later on, but at that point, you will hopefully have enough evidence that will get you out, or because quite often your insurance company will cover you under what's called a reservation of rights, where they can, once it's determined that the thing that you're being sued for is not covered under their policy, they can walk away from the suit. Often what happens though, before you even get there is, if you really don't belong in the suit, you're gone on a summary judgment or maybe even a motion to dismiss. But you should always have the risk shifting and risk mitigation stuff in every insurance policy you get. The players in any situation is going to be the venue location, the event planner and manager, the client association, whatever, and the subcontractors. Make sure that all of those folks are covered under whatever policy, wherever you fit in there. I don't know if we have any actual client types in the room. Although if you've got subcontractors, then as subcontractor, your client is that event planner. So I'm talking an event planner to the subcontractor, or it could be a contract between the client, say an association, a corporation having an event, whatever, and what would otherwise be subcontractors. Like I may have an event planner come in and do the planning and sign a contract with them for that, but then say you got to use these people over here as your florist, as your musician, as your food service, so forth and so on. But make sure that you are covered. The venue desire is to reduce or eliminate liability on its part, and you can work language in the contract that does just that. That says, we are not liable for acts losses arising from the acts of you, Mr. Association, that wants to use my space to have an event. We're not responsible for you, Mr. or Mrs. Florist, who has the contract to do the floral arrangements directly with a contractor that we are also bringing in. You do whatever you can to on the part of the venue to reduce or mitigate liability, and ask them that they prove that they can do it by showing you a certificate of insurance. Same is true for the event planner. You're trying to reduce and eliminate risk, hold harmless for acts not arising out of your actions or inactions. This is something I talked about earlier. You do have some COVID era leverage now with the places where you do your events. They're willing to do interesting contracts I've seen where they're allowing you to name some terms that otherwise they would not have allowed you to do, like COVID protection terms, like agreeing to hold them harmless in addition to you holding them harmless. There was a time when some of the venue contracts were, this is it, take it or leave it. You're holding us harmless. You're indemnifying us, but we're not going to necessarily do the same for you. Now the event planners have the ability, I think, at this point. I don't know how long it will last and how much leverage it really is, but it's there. And so just take advantage of it while you can. I think it's going to be there for a while. You will also, as an event planner, as I mentioned earlier, have contracts with your contractors where presumably you're making sure they hold you harmless from anything that impacts them. And of course, the client of the planner, the association, in this case, the chicken guys and women, want their risk reduced. They want to be held harmless. And again, you have to have proof that you actually have insurance and that you're named as an additional insured on those policies. One of the things you need to look at too is the proof that you typically get to prove that someone has honored the contract to have insurance. It's what's called a certificate of insurance, COI. There is and I shouldn't say this, but I will. There is a cottage industry of faking COIs. Anybody can get in. I can fake one now. I can be everybody who's on this webinar. I can be all of your additional insureds. They're the easiest thing in the world to fake. What you need to do is have at least some form of audit to make sure that the COIs that are being presented to you, and this is typically most important for venues. It's also important for planners, but venues get this more than anybody. You'll get a bunch of fake COIs, which means in order to be an additional insured on someone's policy, you have to actually get an endorsement onto your policy It says, my insurance company agrees to cover these guys over here for the purposes of this single event. And if you don't get that, because I'm not going to cover you just because you asked me to. In order to do that, someone will print you up an additional insured certificate of insurance, and you can hand that to whomever. But those are easy to fake. So take some time and check those out when you get them. I'm gonna move this out of the way. Take this with you wherever you go with all your COVID questions. This is one very good answer from a very good lawyer in the risk management field. Take a second to read it. So sadly, the answer for some of this is who knows at this point. The law is still developing, may never develop fully if COVID gets under control, but the law still is developing. Jeff, I'm done with my presentation, sort of, but go ahead.
Hey, Quintin, I wanted to add, Gwen, I guess before you get started with the questions, because it addresses one of them. Mm-hmm. And that is, as Quintin said, that this is early law, things are very fluid. In addition to that, in addition to the cases themselves, you have various states, governors who are signing into law different provisions as it relates to COVID-19. And that's why, and even them signing it into law, there hasn't been time to even be challenged in court. So a governor can sign something into law, and later on, somebody may go to the state court or whatever the case may be, and say what the governor signed was unconstitutional. It happens. And so it is just another reminder that what happens in South Dakota, you can't take what happens in South Dakota and apply it to Minnesota, and you can't take what happens in Minnesota and apply to Idaho, because the circumstances could be very, very different.
What we had planned to do is to kind of go down the list of some of the questions that we were asked and kind of give some answers or to those. Before that,
isn't Gwen gonna?
Yeah, I was just gonna. Yeah.
I was going to start with some of the questions that are in the Q&A.
Okay.
So the first question comes from David. It's a little lengthy, so I'm going to see if I can do it justice. I got certified in a 3-hour course for a pandemic compliance advisor, for a pandemic advisor position. My company is a live events company. My on-site job will be to be the team mom, in quotes, and make sure all the crew, hotel, and show staff within the event area is tested each day. I will also work alongside Hotel F and food and beverage to make sure they are handled. What is the personal liability on me as a local on-site PCA person for the show?
Is that person, I don't know if it's clear from the question, an employee?
Yeah, their company was hired into this position to manage that on-site portion.
Hello? Oh, I'm sorry, I missed something. I missed, what was it now?
His on-site job, yes, he's hired in on-site. He just wrote in the chat, yes, I am an employee.
Thank you. Typically, you're not going to have personal liability as an employee. That, again, back to what we talked about, that doesn't stop someone from suing you, but typically you won't. If you are sued personally, your company will pick up that under their policy. Let's say you're sued under general liability claim. Your company that you work for will have your back.
Yeah, And always, I always say, watch the money, follow the trail of the money in most cases. And so if somebody was suing,
Yeah.
you look,
What do they want with you?
who has the biggest pocket?
Yeah.
So if I'm homeless with no assets, what good is for them to sue me?
Right.
As opposed to the company maybe
Right.
that I happen to get a job at, whatever the case may be. So
They're,
in a lot of cases, it really does come down to finances.
yeah. They're always going to go after the deeper pocket. Thing one, I suspect you're not the deeper pocket. Thing two, they're always going to go after no pockets here. It's fun. The thing too is that typically, if you were an employee, you're going to be covered under the policy of insurance under, in this instance, general liability that the company has. You're covered.
So the next question comes from Beth. Um, how do we use the term commercial impracticability to force a venue or vendor to give a client's deposit back in the event of a COVID shutdown?
You sue them, because that's the only way. And I laugh at this because I've seen this in a couple of associations that I am familiar with and connected with, and until you and it was, I mean, they threw everything, commercial impracticability, blah blah blah, until they got the summons and complaint. They pushed back on that. What I have found in larger venues, places like Hyatt and Hilton, Sheraton hotels, they're willing to kind of, if it's, and then even then, it's, if it makes a difference whether it's a corporate owned entity, i.e. owned by Hyatt, Hilton, or a what's it called, franchise.
Franchise, locally owned.
Yeah, that they're more willing to give you money back because they're thinking long term that you're going to be down the road. And perhaps, or the other thing, the thing that's even for me, it's a little nefarious, but it's probably a good idea. Look, we're not going to give you your money back, but we're going to apply it to an event down the road. That I see a lot of that happening too. But if they're really, really, really stubborn in terms of the only thing that moves these folks is a lawsuit. Now, I've also seen in one instance where what also moved them was bad publicity, and that was early in COVID, where a company, a venue was like, "I'm not giving your money back." National Organization of Engineers, good luck with that. We're just not doing it. We'll take you to court. And a person involved with that organization had connections to the press, dropped some stories about this company being an a-hole, and they cut a check eventually. But yeah, you may have to sue.
The next question also comes from Beth. What exactly does hold harmless really mean or protect you against?
What it's supposed to protect you against is, let's say you're in a situation where I'm the venue, you're the event planner. You come to me and say, "Hey, I want to do an event at your place." I say, "Great, I love you. I love your money even more. Here's some paperwork, please sign it." You're sitting at my desk and you're reading and says, "What does this mean? Indemnify and hold harmless." Essentially, what indemnify means is that you're agreeing to pay them for any loss arising out of the event or acts that arise out of the event. Hold harmless means basically if anything goes wrong involving that event, or and this language is used all over the world of insurance and insurance law, but it applies to general contractors building that large building outside of your office, if you're still in an office, or it applies to if you're catering a party or a wedding. you agree by agreeing to hold someone or some entity more than likely harmless is you're basically saying you're not going to have to pay anything for this lawsuit that happens arising from this event. Now, two quick things. One, typically you cannot, most jurisdictions, this is why I say hire a good lawyer wherever you are, most jurisdictions will not allow you to sign away or slough off onto someone else your liability. So let me give you an example, the hotel thing again. You have guests coming to the event that you put together for the Chicken Association. Walking through the hallway to get to the banquet room, one of the guests slips and falls on a tear in the carpet, breaks his leg. The tear has been in that carpet for months, and the hotel either has done nothing about it or did a shabby job of dealing with it. That injury, while the person was in fact going to the Chicken Association event, the cause of that injury was not in fact anything that you as the event planner or the association, that had little, if anything, to do with anything that you did, and had everything to do with something that the hotel did. So let's say there's a lawsuit that arises from that person breaking their leg. And as I told you, when they sue, they're going to sue everybody. They're going to sue you, the event planner, if they can find you. They're going to sue the association. They're going to sue the venue. What many jurisdictions say is that, look, under that set of circumstances, you cannot make this the person who's making you an additional insured on their policy be responsible for what is probably your negligence and your negligence alone. Now, does that mean you get a get out of free jail card for that suit? Nope, because somebody's still going to file it. And as I said in my presentation, there's no one at the clerk's desk saying, you can't file that suit. And let me tell you why. No one does that. Eventually, it will work its way through the system. People will get service of process on you. You will then have to appear. What will happen is you'll get a notice that you've been sued. You'll get a copy of the complaint. First thing you do is call up your insurance company and say, I've been sued. I'm shocked to find that I'm being sued. Shouldn't be shocked at all, because everybody's going to get sued. And it's handed off to an insurance defense law firm. That insurance defense law firm will file an appearance on behalf of your company or you or both, and they will defend that suit vigorously and to the ends of the world, after they bill it file now. And then what will happen is they'll say, it's an issue of fact out there whether or not the tear in the carpet was caused by whoever, and you'll get defended. But the reality is, this is a long answer for a short question, that they're typically hold harmless. You agree to take over whatever liability that the individual that you agree to hold harmless has. However, if that liability arises out of strictly that person's behavior and has nothing to do with you, typically you're not going to be required to hold them harmless.
And gross negligence.
Yeah, well. And gross negligence. Yeah.
Gross negligence, if you do something that's grossly negligent, even though you signed a hold harmless, like Quintin is saying, the court is going to go after that person who was grossly negligent. So oftentimes you take a youth group to a gym and you use the gym for basketball practice, and they have a nail sticking up in the middle of the floor. That's gross negligence. So even though everybody signed a form saying that you're not going to hold them harmless, they will still be held liable. Yeah.
So the next question is from Lisa. It says, does mutual reciprocal indemnification clause impact impossibility clause in a hotel contract?
When you say a project, what do you mean?
Yes, maybe you say that again. Read that again, please.
Does a mutual reciprocal indemnification clause impact an impossibility clause in a hotel contract?
You know, essentially what a mutual, I mean, it's, I'm tongue tied here. Indemnity, what it just says is that we'll both deal with each other's issue. And we're here together, you know, we are the world singing, you got it. So in a sense, that kind of agreement typically only comes into play when there's a third party action. What we're talking about is with the impossibility issue is a second or first party action where you're saying to the venue, I can't do this event because of COVID. And they're saying, yes, you can. And then you say, no. They say, yes, you can, because there's no law out there right now that says you can't do this event, especially if the event is a little ways off yet, which is what I saw a lot of. You know, you had events that were scheduled for October, especially in warm places like Cali and Florida, but you're trying to get out of them in May of last year. And the hotels were like, we don't want to let you out of this because this whole thing could blow over by October. Now, if you have a mutuality agreement, typically that's going to cover if some person is injured other than the two people to the parties to the contract, and not necessarily deal with an issue around, you know, we need to get out of this contract because down the road we think COVID's going to be an issue.
Yeah.
Well, speaking of COVID, this next question is kind of specifically about that. It comes from Stacy. Says, I have a signed and executed contract from last June for a September event. The client has chosen to move the event to March due to COVID. I have sent them an amendment to the contract, moving the date and the remaining payment due dates only. They are now taking this opportunity to make amendments to other terms, rewriting some terms and completely changing others.
Of course they are.
Particularly changing force majeure and photography clauses. I am not comfortable with these changes. How would you advise to proceed? Should I acquiesce and make these additional revisions and stay firm on just changing the dates? They are insistent that these changes be made in order to amend the contract.
Before you answer, Quintin, let me just say this.
No, I was just going to say,
oh,
yeah.
No, okay, well,
You know what
I was going to say,
think.
you know, and then probably maybe should have given this disclaimer before. You know, we are not giving specific legal advice. Okay, we would never do that. I don't know what state different people are, and I'm licensed in Illinois, and I can't give advice to people outside of Illinois, and I wouldn't do that even in Illinois. So really, we're just talking about generalities. Okay, so
Like you were in a law school class.
yes. So generally, when you're looking at a situation like that, you need to take everything into consideration. Okay. The biggest thing from a very practical viewpoint is, do you want the contract? Do financially, do you still want to follow through with this contract? Okay, so you may say, I come hell or high water, you know, this is a great contract for me, I want to do it. Or you may say, I kind of been wanting to get out of this anyway. Okay, depending on what spectrum you on, really is going to help dictate how you are trying to negotiate. So take all those factors into consideration. And the best thing I can say is, just really work to get the best deal for you. So these extra clauses that they want to put in, worst case scenario, if you put those clauses in, okay, would it still be a contract? Is it still a situation that you want to be in? If you can say, even if I gave them everything, I still want to be in this contract. Then you kind of work back from that and get as much as you possibly can. Take into consideration your, the specific things that you are doing. And I don't know if that answer was too vague, but literally they need to take everything into consideration. People are going back, they are changing things. After 9/11, people were putting in terrorism clauses in the contracts. Now people are going back and putting pandemic language under the force majeure, and then under the force majeure it says, well, if this happens, this is how we're going to deal with it. You also have, when you also want to add a note, when you're talking about impossibility, you have to also add on there the issues of restitution. In other words, even if the contract is impossible for you to fulfill, okay, that still doesn't mean you should be unjustly enriched. So you still have to look in some cases where there are deposits paid and that sort of thing, that money has to come back. The gray area is going to be where the impossibility comes in, but you expended money on your side in anticipation of this contract being fulfilled. That's where you're going to have some issues about what is it that a person, even though it was impossible to fulfill, what am I owed?
Yeah.
What am I owed back?
Detrimental reliance.
Yeah.
So we're probably, oh, go ahead.
I
really only have time for one more question.
Oh, really? Oh man, how time flies. Okay, go ahead and ask the question, because I had some other stuff to add to that, but I'd rather have another question.
Okay.
And I'm available to answer questions to any of your members whenever they want me. So I'd be happy to if they're.
I would love that. So if if there's anyone out there that did not get their question answered, please feel free to just include that in your survey, and we will get them over to Quintin and Jeff to get them answered. But the final question is, how can I get hotels, vendors, and venues to agree to put my deposits for an upcoming event in an escrow account?
Mm-hmm.
I want to put the future deposits in an escrow account, but the hotels say they do not allow it. It took me 6 months to get one of my 300 deposits back from a hotel due to them canceling from COVID, because they said they did not have the money. They've had my deposit for over a year now. How can I get it?
Oh, they still have your money?
That's what I'm.
Yeah. Wow. Yeah. So with many of these hotels, what I've seen with the larger entities is that they're cutting checks and returning money. There's some of these mid-level and the boutique hotels and places that are a little crafty about it, or they truly don't have the money because they took it from what should have been a form of escrow to begin with, and they've spent it already. Yeah. And they and that's an issue. The way you're going to get your money is by either, and let me tell you this, threatening lawsuits never scares anyone, because everybody thinks you're going to threaten a lawsuit. But I would definitely pursue whatever jurisdiction you're in. Maybe you can even get someone to take it on a contingency fee basis to go after getting your escrow or getting your money out. I like the concept of putting it in escrow.
Putting it in escrow, yeah.
That's a nice idea, and that's one of those things I was talking about. In this day and age, a lot of hotels or a lot of venues will just do whatever it is to get the client in the door, and that could be one of the things that you can negotiate. Look, it's a free market. That's the beauty of this. There's no requirement that you do that a contract, other than offer and acceptance and some other things, that you can put anything you want in a contract. Now, again, if you're dealing with the big boys, Hilton, Hyatt, whoever, they may say, no, you're going to sign this contract or go elsewhere. Even some of them aren't doing that anymore, because they want this, they want that money that comes with, especially if you represent an association, they want that money badly because they know down the road you could bring them 10 events in a year or so.
Yeah, but I don't see any
Well,
reason why they
post-COVID.
wouldn't put it in a escrow. That was I think the other part of the question. I don't see
Yeah.
any reason why they could not
Yeah,
put it in an escrow account. Because even if they don't have an escrow account, they can go to the bank and say, open up an
Right.
escrow account, and they can put that money in there. So, she has to, or he or she has to be very persistent. Hopefully that helps.
for those, someone just put up my email address. You should put the firm email address along with that.
We will do that. I just want to thank you both for joining us, and I'm sure you're going to get lots of questions for follow-up because we have. So, but remember, you opened the door.
Oh, I'd be more than happy to respond. Love it.
We
absolutely love
appreciate your time, and we appreciate you having this conversation with us. Thank you so much for joining us, and thank you for everybody attending today. We appreciate your time, and we will see you at our next ILEA webinar. Thank you so much.
Thank you. Thank you for having us. That was fun.